Information presented in this podcast is provided for general information and is not intended to be legal advice for any specific situation. Welcome to the Nonprofit News and Knowledge Podcast, sponsored by NonprofitLawChicago.com and the law firm of Bea and Vandenberg, serving nonprofits from Chicago all over the nation. We've been talking about nonprofits. Now we're going to change and talk about for-profit structures. So I mentioned in the first part that nonprofits are unique because they do not have owners. Even if founders sometimes think they're owners, they're actually not. Nonprofits have directors. Well, now over in this other side of things, all of these various structures that we'll talk about, the for-profit structures are all owned by somebody. It can be one person or more. There's a very simple, easy way to organize, and there are other ways to organize that involve entities, and the organization can be very structured and complex if you have a lot of owners and investors, but otherwise it can be very simple. The easiest way to do business is just to do it yourself as a sole proprietor. But the business will have no separation from you whatsoever, meaning if you can't pay your bills in the business, the creditors can come after you personally. There's no distinction between you and the business. You file your regular tax return, the 1040, and you include Schedule C. That's where you report your business. I don't recommend it because there's no protection for liability. Partnerships have the same trap in that there's no protection of the partners from liability, and worse, you can be held fully liable for what your partner does. So if your partner runs up a bunch of bills in the name of the partnership and then runs off, you can be left having to pay them. So partnerships are not ideal either. And then there's limited liability partnerships, and that's really just a spin on partnerships that protects some of the investors who are not involved in the management of the business, but anybody involved in managing is still subject to that liability. So we'll set those aside and say those are not really suitable for social enterprises for the most part, with rare exceptions. And we'll say, let's talk about the entities. And we really have two major types of entities, either corporations or LLCs. Now, a corporation is an entity, and an LLC is an entity. And what that means is it's a separate legal person. It can own property, it can enter into contracts, it can sue, and it can be sued. Liabilities that belong to the business, for the most part, do not reach the persons who own the business, with some exceptions, but typically they do not if you do things right. And so you get protection from liability with a corporation. You also get protection from liability with an LLC. LLC stands for Limited Liability Corporation. So some people think only those will protect you from liability and corporations won't, but that's not true. They both protect you from liability equally well. So now we've been talking about two kinds of for-profit business entities, LLCs or corporations. Now there's a cousin of each. To the corporation, there's something called a benefit corporation. And to the LLC, there's something called an L3C. So let me explain. A benefit corporation is a type of corporation that is incorporated in the state just like a corporation. And I'm really speaking here about Illinois law, and about, I think, 20 or so states as of this moment have benefit corporations. So they're not available everywhere, but they do exist in quite a few states. And what they are is they're intended to show that their primary purpose is to accomplish some social and public benefit. But let me get to that in a minute. That's a little bit ahead of where we are right now. So I just want you to know there's two types. There's business corporations, there's LLCs, and there's variants of each. The variants are designed to be sort of branded as social enterprises, and we'll get to that in a minute. So let's go deeper on corporations first. You can get by with one shareholder and one director, and that can be the same person. So it can be a one-person operation. Your corporation purpose is anything that's lawful. Any lawful business that can be incorporated under the Business Corporation Act can be incorporated. Now, there's special kinds of corporations that are used for banks or for professional groups such as law firms, or for other kinds of medical groups and such. But for the kinds of things we're talking about, social enterprises, a corporation is a perfectly good vehicle because accomplishing a social or charitable or environmental purpose is a lawful business activity. So you can do it as a regular business corporation. There is an interesting old legal case called Dodge versus Ford Motor Company, from all the way back in 1919. And it was here, by the way, the Dodge brothers, John and Horace, who founded the Dodge Motor Company, were shareholders in the Ford Motor Company at this time. And there was a lawsuit between these shareholders and the company over a variety of things. And in this case, the judge voiced an opinion. It wasn't really the issue that was being decided in the case, but the judge voiced an opinion. We call this dicta, where he said it is the director's duty, fiduciary duty, to make a profit. And so people often say that corporations must make a profit for their shareholders. That's their primary objective. And it's probably based on this case. Interesting trivial fact is that John and Horace Dodge died of influenza in 1920, the year after this case was decided. So to solve that problem of the primary fiduciary duty being to generate a profit, the benefit corporation was born, and it shall have as a purpose, it shall have a purpose of creating a general public benefit. So that's right in the law. Now, arguably, you can do that with a business corp too, and there have been a lot of criticism by legal commentators and other cases, other judges, of that decision in that 1919 case. So it really doesn't appear that the law requires shareholders to generate a profit. Directors to generate a profit for shareholders. It's conceivable that they can do a social enterprise in a business corp. I guess what I'm saying is I'm telling you a lot of layers of possible options for corporations here, but in reality, either one would probably be suitable. What a benefit corporation will do for you is, and by the way, the law does say that the director's standard of conduct shall include considering the effects of anything they do on the shareholders, of course, that's traditional, but also employees, subsidiaries, suppliers, customers as beneficiaries of the company, the community, the environment, and society. And so it makes it very clear that you can do a social enterprise with a benefit corporation. That's really what they were intended to be used for. And they have a way of signaling that to the world. There's a branding element involved in being a business corporation. They must file things every year, and kind of like nonprofits, they have to file annually with the Secretary of State to keep the corporation alive. They have to file an annual tax return, only in this case it's an 1120 or an 1120S. And they do have to, unlike a regular business corp, here's the difference. Regular business corp, no requirement of public disclosure of finances. Benefit corp, there is a requirement. And the Attorney General requires registration, just like they do for nonprofits. Interesting. There's also other filings, just like any other business, like employment tax or sales tax. So benefit corps are fully taxable. They're for-profit businesses. They're owned by somebody, but they have as one of their purposes the creating a public benefit, and they can consider the effects of what they do on the environment and the public and all of that we talked about. So that's the benefit corporation. Interestingly enough, I think that public disclosure thing, in my experience, does tend to turn off a number of people who think about forming these. It's one more thing they have to do. They might not like disclosing their finances because they, like any other for-profit business, have competitors. And they'll be disclosing their finances to competitors, whereas competitors won't have to disclose the finances to them unless they're benefit corporations. And so that can be seen as a drawback, and that will cause some social entrepreneurs to choose a regular corporation. Now let's shift over to the parallel universe of LLCs. As I mentioned, these do protect from liability. Just like corporations, you can organize one with one person as the owner, or you can have more. There's some very technical ways that these can be more flexible. It's kind of beyond the scope of this particular podcast to get into that, but just to say that as a planning tool, LLCs are sometimes ideal for certain complex situations. And then they're also flexible tax-wise. They can be taxed like a sole proprietorship. They can be taxed like a partnership. And they can be taxed like a corporation. And so you obviously need legal counsel to help decide what's best for you in that regard. The LLC world has a lot of the same characteristics as the corporation world, but the terms change. So in corporations, the owners are called shareholders, but here in LLCs, they're called members. In corporations, the people who run it, who are responsible for it as the fiduciaries, are called directors. But LLCs can have managers or a manager. In corporations, an essential corporate document is the document called bylaws. And in LLCs, there's no bylaws, but there's an operating agreement. And so these are all the same ideas, but they have different terms. So now let's talk about the social enterprise cousin of the LLC. It's called an L3C, which is a peculiar name. It stands for Low Profit Limited Liability Company, and it must be the three L's, low limited liability, low profit limited liability, that caused them to say L3C. It's very similar to a benefit corporation in a sense, in that it too must do public disclosure via the Attorney General, because the Attorney General will require its registration just like a charity. And so that is a drawback to some social entrepreneurs saying, well, wait a minute, we don't really want to have to give away our, show our finances in a public way, because that can help competitors, and it can also just show our current financial size, and we don't necessarily want people to see that. So that's a personal decision for the entrepreneur who's setting one up, whether they would want to do that or not. And like the benefit corporation, they shall significantly further the accomplishments of one or more charitable or educational purposes. They cannot have as a significant purpose the production of income or the appreciation of property. But it's okay if it happens. And like nonprofit tax-exempt organizations, they cannot have as one of their purposes accomplishing a political or legislative purpose. Now that's interesting. That's not in the benefit corporation law. It is in the L3C law. It makes them a little bit like tax-exempt nonprofits, yet they are fully taxable. So are you confused yet? I hope not. Finally, the last thing we need to talk about is the certified B corporation. Now, people get confused. Is it a benefit corporation or a certified B corporation? They're not the same thing. I just mentioned a benefit corporation was an actual type of corporation that's set up under state law. A certified B corporation is not an entity. It is a certification. It's a stamp of approval from a credentialing body, okay? So B Lab is the name of the nonprofit organization that will grant these certifications, has an application process. It's pretty laborious. And they will grant certifications to any company of any type that meets their requirements. And then you can brag about how you're a certified B corporation. They do require transparency. Their website gives lots of information and ideas for the social entrepreneur. If this looks attractive to you, you can study their website, which is bcorporation.net. The letter B, the word corporation.net, that's their website. It's the Certified B Corporation. It's an application, it's a process. There's an annual fee. The minimum is, I believe, $500. It can go up to a $50,000 annual fee depending on the size of the organization. That's how the nonprofit B Lab generates much of its income to operate. And it does create a community. So you're part of something. You're part of an exclusive club when you're a Certified B Corporation, and that may have benefits. Both the Benefit Corporation as an entity, the L3C as an entity, and the Certified B Corporation certification will essentially function primarily for branding purposes. It signals to the world that the corporation is about creating a public good or furthering a charitable or educational purpose, and that's really what they're about. Otherwise, you can do a social enterprise with a regular corporation or an LLC, not have the public disclosure, and still be a social enterprise. An example, a coffee roasting company that hires ex-felons who've just gotten out of prison, or felons who've just been released from prison, ex-cons. They're very unemployable for the most part, so they make it as their mission, hiring those people, giving them a job record post incarceration to help them get back on their feet and help them really re-enter society as a contributing member, and hopefully to avoid recidivism and to stay out of jail. That's a great example of a social enterprise. There's no reason for something like that to be organized as a benefit corp or an L3C unless the people running it feel that's a benefit. So there you go. That's the essential characteristics of the for-profit world. It's a confusing array of choices, of course, and so the net on that is you really do need some legal counsel, even a little bit up front, to decide based on what your mission plan, your business plan is, and what your mission is. How should you best structure in order to accomplish your goals? And that does require some professional advice. This podcast, of course, can't give you that professional advice because we don't know your exact circumstances. But by all means, check with an experienced attorney and get some counsel. And also check with an experienced accountant and get some counsel on that. Like, what would it be like to do the taxes for this type of organization or this type of organization? Are there any pros and cons? And taking all that information in will help you. In addition, you may have resonated with one part of this presentation or another. One part or another may have felt more at home, and so that might be the right place to go. To be a charitable and nonprofit and tax-exempt 501c3, you do have to have certain specific limited purposes. It is a difficult test, and again, legal counsel can help you figure out, will you meet those requirements? Would this actually qualify as a 501c3? There are lots of people who will organize things that really should not be tax-exempt organizations, and they'll try to organize them that way. And they can have difficulties. And so that's a reason to get some counsel. So I hope this has been helpful in considering the different ways to organize for social enterprise, and that it has sparked some ideas. And if you have any questions, by all means, contact the law firm of Bea and Vandenberg. I'm David Bea, and I will speak to you again. Information presented in this podcast is provided for general information and is not intended to be legal advice for any specific situation. Welcome to the Nonprofit